SJC-12781, Catherine Drake v. Town of Leicester.
Sorry.
Good morning, Your Honors. Tom Book.
Wait one moment.
I'm sorry.
All right, Mr. Vukmirovitz, you may proceed.
Thank you, Your Honor. I apologize. Good morning, Your Honors. My name is Tom Vukmirovitz, and I represent Catherine Drake, the appellant in this case. At issue here is what constitutes a timely presentment under the Mass Torts Claims Act. The lower court ruled in allowing a motion to dismiss the complaint that it is only upon receipt by the public agency, and I respectfully contend that that ruling is incorrect. Your Honor, the facts of this case are just very undisputed, and certainly looking at it from the complaint's perspective. The injury occurred on January 19, 2016. A presentment letter was mailed on January 19, 2018 regarding Ms. Drake's damages, which arose from a slip and fall on accumulated snow and ice at a high school where she was picking up her grandchild. She fractured her knee and wrist and contended that her injuries were caused by the negligent maintenance of the property. On January 22nd, 2018, the notice was received by the town. February 7th, the claim was denied and suit was filed March 26th. Under 258.4, the cause of action arose on January 19th, 2016, and under that statute had to be presented through the form of a presentment letter 2 years after the date from which that cause of action arose. The lower court construed that the facts of this case amounted to constructive notice that was rejected by the Weaver case, and also used a dictionary definition of presentment. And that's on the appendix page 46 of her opinion. What she did not do, however, is look at the analogous Federal Torts Claims Act, which courts in this jurisdiction, including this court, have held that the Mass Torts Claims Act is closely modeled after the Federal Torts Claims Act. In the Federal Torts Claims Act, there is a precise definition of how presentment is made, and the CFRs use the word received. When the public agency receives the notice, then a presentment is effectuated. In the Mass Torts Claims Act, there's no definition of presentment in the definition section, and all the cases that I found only...
Does the federal statute use the word presented as well?
I believe, yeah, I believe presentment is, in the CFRs use the word received, and I believe under the Torts Claims Act, I believe it's
Well, that's
presentment.
different. Received and presented are, not, I mean, aren't necessarily the same word. Does the federal statute use the word presentment or presented? I'm just curious.
I don't think it does, but if it does it use the word receipt?
The CFRs clearly use receive. I attached that in the appendix. It's in...
PFR does, but the statute does not.
Right, right. And the CFRs, how you present the claim. And I think, I'm not sure the reasoning behind that, but I presume because of the federal agencies are much larger, it would be harder to prove receipt when you're talking about a national agency versus just a state agency.
Do we model ours on the feds?
Yes, there's case law that in the Vassis case and the Gavin case, I believe, make reference to the fact that the Mass Torts Claims Act is closely modeled after
Yes,
the federal.
but does it help you to have it be receipt?
Well, no, because there's a clear definition under the Federal Torts Claims Act that it has to be received, and there's
saying-
no.
But it doesn't
Separate,
use
yeah.
presentment,
Yeah.
he said. Presentment is the word that we're looking at, and that's not in the Federal Tort Claims Statute. So how do we make the,
Because if the legislature wanted to use the word received, it could have done so. It could have included in the definition section. It clearly could have defined and described how a claim is made.
So it's only sort of modeled on the federal act?
Excuse me?
It's only sort of modeled on the federal act?
Well, the case law says closely modeled, so
I mean, I know that, but
yeah.
I'm saying I don't understand how it helps you other than to show the difference.
Because if the legislature wanted to hold that the claim is presented only upon receipt of the agency.
Are you saying they would have done it expressly? They would have
Yes.
done it expressly.
Yes, that they would have used that word if that's what they meant.
That assumes the CFR was done before the Mass Tort Claims Act. Do we know whether or not the CFR was written before then?
I don't know, Your Honor. I apologize.
So the mailbox rule, however, I guess was well-known at the time that the Tort Claims Act was enacted with regard to civil matters.
But the one, all of the cases that I found, Your Honor, just talk about the date of the injury and then just go forward 2 years later, and that's when the claim has to be presented by. There's no instructive language about any case. The only case, as cited by the defense, is the Superior Court for Debt case, which involved I think a rape claim on September 25th or 26th, and there was 3 separate notices that were sent on 2 years later to the date, on September 26, 2017, and then there was an issue of fact as to when those 3 letters were received, either the 27th, the 28th, or early October, and that's why summary judgment was denied. But in that case, even in that case, the court held that there's a statute of limitation analysis to be employed, and the statute of limitation it's not to avoid running the statute. You just have to file it in time. You don't have to serve the complaint in time. And also the underlying the reasoning of the lower court completely ignores the fact, if you use this definition of presentment, that it has to be there on that day. The office was closed that day. So this,
And it was received in the next business day, was it?
I believe, on the next business day, yes.
You make that point below?
It was received on January 22nd. It was mailed on the 19th. I believe the 19th, I believe, was a Friday.
And that day was, the offices were closed.
The offices were closed that day, yeah. So
You
even
couldn't
if
have presented it, even if you went in person, you couldn't have presented it that day.
No, and even if it was mailed the day before or 2 days before,
And it got there that day, so it
Yeah.
got there it got there on Monday, in other words, it was received on the Monday.
I don't know.
Factually,
Yeah, it was received the next, I think the next available business day. There might have been Martin Luther King holiday at that point. But the office was closed that day. And so if there is a determination and a holding that presentment is made only upon receipt, then I'm not sure how results can be consistent. I mean, it doesn't account for delays in mailing. It doesn't account for weather emergencies or anything like that. So for that reason, in statutory interpretation and construction, I contend that presentment, as intended by the legislature, is complete upon the mailing. And that's consistent with the interpretation of the statute. I believe the Weaver case talks about that there's strict compliance necessary for compliance with the Tort Claims Act, but there's specific mention that the only time that the statute is strictly construed is in terms of sending the notice to the proper agency. It's never been applied in terms of a timeliness issue. It's only sending it to the right executive officer. And in the Weaver case, there was timely compliance with the initial letter, but it was sent to the wrong agency or department. Then by the time the right letter was sent, it was after the 2 years had passed. And that's why, in that case, there was a notation in the decision that although this is a harsh result, this is the way the statute is construed. But in that case itself, I believe in the Belanti case, the Vastus case, the Gavin case references the fact that there's a liberal interpretation and construction of the statute.
so you're making the argument that it should be a rule that says it should be complete on mailing rather than on receipt, but you're also saying that here factually, you should win because the office was closed on the day that it was due, otherwise due, and receipt was on the next business day. Are you saying you have one, that the theory should be different, than what the judge basically did. But it's also, as a matter of fact, you should also win on the fact because it was closed.
Yes, if the statute, for instance,
Requires receipt. If it requires receipt, then you win on that one too.
if it requires receipt on that date, then.
Well, on a date that it's closed, it couldn't possibly do that.
Right. That's why my argument is that it doesn't seem to make sense if you adopt that analysis. And
Okay, thank you, sir.
right, may I just close on one note? In the Weaver case, that there is specific language in that case that where the issue was whether or not there was prejudice needed to be shown, because in that case, the claimant was trying to get around the fact that it wasn't done in time. And there's language in there that says that had this legislature intended to require showing of prejudice, they would have included that in the language. And similarly here, if the legislator intended that presentment is made only upon receipt, then it certainly would have included that in the language. And thank
You
you
know
very
why
much.
the office was closed that day?
Do I know why it was closed that day?
Yeah, was it a legal
They're
holiday?
not,
Was it
no,
legal?
it's not open. It's not on the record, but I called to find out, and there's certain days of the week that it's not open. So there's certain, it's in small towns, unlike a larger city, these,
They're not open every day.
they're not open every day, right?
Okay, thank you. Ms. Garland.
Good morning, Your Honors. Chief Justice and Associate Justices, may it please the Court. Melina Garland for the appellee, Town of Leicester. Even if we accept Ms. Drake's argument that, even if we accept the facts in her complaint as she's pled them, it's quite clear that no one at the Town of Leicester had notice of her claim within 2 years as the statute requires. And it is our position, of course, that her suit was properly dismissed because she failed to present her claim to the appropriate officer of the town within the 2 years set forth in Section 4 of the Tort Claims Act.
So how should we read in writing to the, shall have first presented his claim in writing to the executive officer of such public employer? How should we define that?
Our position is that it should be read to say that the presentment must be received by the end of the 2-year period
Received by whom?
by the appropriate officer.
So who's the appropriate officer in the town of Leicester?
The statute defines that to include, I believe, the town clerk, as well as, I believe, the Board of Selectmen.
So what if it's sent to the town clerk, or the town clerk is on vacation for 2 weeks? What happens?
I think it would be a reasonable interpretation to say that if it's received in the town clerk's office by the end of the 2-year period, even if the town clerk, him or herself, is absent, that would be sufficient.
There's no notice to the town clerk. He's not there.
That's a fair point, Your Honor.
So how is that different from the mailbox rule?
I think the difference is that while the plaintiff or the claimant cannot control whether the town clerk is present in his or her office on any given day, the plaintiff does have control over whether and when her presentment is in the office. And
How? How does she have control over that, just in terms of, I mean, once you put something in the mailbox, you have no control over when it's going to get to where it's going?
And that's unfortunately true for everyone, and I'm sure we've all had experiences where we've mailed a letter and it's arrived someplace perhaps very close, more than a week later, more than a month later, or it's been returned for some reason, whether it's a wrong address or a lack of postage. But the history of the Tort Claims Act and the 41 years of case law interpreting it have made clear that the burden is on the plaintiff to comply with the 3 main components of presentment, which is in writing to the appropriate officer within the 2-year period.
Is that why they give you 2 years?
Right.
I'm not sure why they chose a 2-year period, Your Honor, but
But it's
2
not
years.
the next day, so
Yeah, you're not, you have time to get this done if you're conscientious. And it's never been I mean, when you have to do the chief executive, the mayor's office, you don't need the mayor to read it. It's the office, right? And the officer, the people who work for him or her. I mean, we've never interpreted that language narrowly, have we?
I don't believe so, no, Your Honor, and I think that's correct.
So I think if you put you put it in the mail a week before, and it gets rerouted, and it ends up there 2 days late, I think that's I'm not sure that's even a hard case. Maybe that gets excused, but that's not what happened here.
But what do you do with the fact that it was closed?
As my brother said, this is not in the record, but the town hall in Leicester is never open on Fridays, and I would submit that a 2-year period is a very generous period of time.
But it's 2 years, it's 2 full years.
2 full years.
And that means that one day of it is not counted for, right?
I'm sorry?
The last day they didn't get because it was closed. In the 2 years, right? So it's 365 days times 3 or, whatever. But the last day is something they're entitled to, right? And they didn't get it because your office was closed. So why doesn't it count that it got there on the next business day?
I would submit that the statute doesn't provide for that. The rules of civil procedure, for instance, specifically provide that where a deadline falls on a weekend or a holiday, the deadline is moved automatically to the next business day. But the Tort Claims Act does not provide that. Section 4 does not say that. And if the legislature had intended to extend the period in that way, they certainly could have done so, just as they could have muddled that portion of it after Rule 3 of the Rules of Civil Procedure and said that you could present the claim merely by putting it in the mail using certified mail rather than having to go to a particular office.
Was
And they-
January 19th a Friday? Do we know this?
As January 19th, 2018 was, I believe, a Friday.
So that's how, okay, so it was a Friday and the office is closed on Fridays. Mhm. Okay.
Yes, Your Honor.
So if she had tried to walk it there and found the door locked, she just would have been out of luck.
I suppose she could have put it under the door. She would still have a problem of proof as to receipt in the town hall that day. And I think,
Don't want
while
to do that in a town, do you? You don't want to put it under the door of the town hall.
that's not the method I would choose, certainly.
So whose burden is it to prove that it was timely presented? It's the plaintiff's burden, correct?
It is, Your Honor.
So how is a plaintiff supposed to prove that it was received without being able to obtain that information from the town itself?
Well, one of the ways of doing that is certified mail. One of the ways of doing that is going in person and asking for a receipt that it's been submitted or a date-stamped copy. I think there are several ways of ensuring that you can later demonstrate that it was timely, just as the evidence in this case indicates that it was received outside of the 2-year period.
But if you just mail it, just drop in the mailbox, you'd have to depose or have some information from the town itself to be able to allow you to prove that it was in fact received.
I believe that's correct. If it were simply first-class mail, there would have to be some testimony or other evidence from the town in order to demonstrate receipt.
Does the fact that it's closed matter at all? Because it's mailed on the day it's due, which is risky business, even if they were open, right?
I agree. Unfortunately, and I think this is probably a lesson many of us have learned at one time or another, that when something is left to the last minute, things may not go quite to plan. And that's why I emphasize that it's the plaintiff's burden and responsibility to ensure that it's there ahead of time, that it's there on that last day. I just would also like to address my brother counsel's argument that strict compliance in the history of jurisprudence on the Tort Claims Act does not apply to the timeliness requirement. There are at least 3 cases where timeliness is included in the description of things that a plaintiff or claimant needs to strictly comply with, including Martin versus Commonwealth, Tivnan versus the Registry of Motor Vehicles, and Estate of Gavin versus Tewksbury State Hospital. And the reasons for that, the reason to support a bright line rule that it must be received is that that provides clarity for both the claimant and the public employer who is working with limited funds and many financial commitments among which they must budget. One of the purposes of the Tort Claims Act and of the presentment requirement are to give the person, the executive officer of a public employer, the person with responsibility for its finances and its operations, notice of the claim, an opportunity to investigate it, and to ensure that non-meritorious claims are not paid, but also to allow an opportunity to settle meritorious claims in order to limit the amount of time that and money that public employers are required to spend in litigation. And that bright line rule will better conserve those resources and will also avoid situations where a letter is mailed even well within the presentment period but isn't received for 2 weeks or several months or even a year, or is never received for reasons completely unknown. What Ms. Drake is asking for is that the town be deemed to have notice as of the date that she has put it in the mail, and I don't believe that a fair reading of Section 4 of the Tort Claims Act supports that conclusion. That's at best constructive notice, but it's really no notice at all.
Okay.
If there are no further questions, I thank you very much.
All right. Hear ye. All persons having anything further to do before the Honorable